Hi, this is Scott Pierce. Welcome to our seminar for community property. If you do nothing else to prepare for this subject on the California bar exam other than review this seminar, you're almost certainly going to be well prepared for any conceivable issue that will arise. California community property is the easiest subject on the California bar exam for two reasons. Reason number one, community property has fewer issues than any other subject. Reason two, these essays are the easiest to organize on the bar exam. Evidence and community property are the two easiest subjects to organize. Here in community property, we consider every item of property in the marital estate the same way. We use the same structure of analysis for every last one of them every single time, and it always works. Now, what do we have to be ready for in any community property question? Answer: we've got to be ready to consider all of the facts about the marital relationship and about whatever property is involved in the question. So, take a look at the very brief community property approach. The very first thing you're supposed to do in any community property question you ever get is establish that California community property law applies. Now, let me tell you how you do not do this. The way to do this all wrong is to start off your answer with 1 or 2 or even 3 pages of boilerplate. Anybody who tells you that you've got to recite a lot of law to do well on any California bar exam essay question doesn't know the first thing about California essay writing. The California bar exam is looking for factual analysis. That's the name of the game. And so, obviously, you've got to know plenty of law, and you've got to work a lot of legal details into your answer. But the way to do it is to ground everything you do in factual analysis. Let your law knowledge be used to structure your answers and to provide intellectual content to the answer. But remember, in all essay subjects, and maybe more so in community property than in any of the others, the facts matter. You need to find a home for every single detail in these questions. And as you review my written answers, I think you'll find that's exactly what I do. So, up front, we consider facts related to the couple. Do California community property laws apply? And here's where we talk about quasi-community property issues if we have an out-of-state marriage moving to California and becoming domiciled here, or if we've got a meretricious relationship or a prenuptial agreement. These are ideas that we consider up front. Then we get into a discussion of the marital estate. And for each item of property, we talk about the source of that property, and we go into very specific detail about the facts. And what we're looking for here is to establish whether the source of the item of property is community property or separate property. And that applies to obligations as well as to assets. So, if you look at the approach, you see that there are 3 basic sources of separate property: gifts and devises, personal injury damages, and property or debts acquired before marriage. These are all separate property of whichever spouse is the holder. Notice that there also are sources of community property, and these are earnings during marriage and educational degrees and professional licenses earned during marriage. And we'll see these issues tested ritualistically over and over and over again in exactly the same way. And that's what makes this subject so easy to learn and so easy to do well on, if you're well prepared. With regard to source, remember that to quite a reasonable extent, tracing is allowed to determine the source of the property. One idea that I think is well worth keeping in mind is that the bench officer, the judge in California Family Law Court, basically is sitting in equity, and she or he has got plenty of authority to do pretty much whatever is necessary in order to create a fair distribution of the marital estate. Now, it certainly is conceivable that a judge could abuse that authority and do something that would actually be overturned, but that's not what's going on in these questions. What we're being asked about really is to characterize whether the property is marital property or non-marital property, in other words, community or non-community property, and then we're being expected to show some depth of understanding about how California resolves these property issues. So, once we're done considering the source, something we do for every item of property in every question, then we move on to consider the actions. And in the outline, I've listed a number of possible actions. But remember, what we are going to do here is allow the facts in the fact pattern to trigger the analysis. So I list these actions not as a comprehensive list, but just as examples of classic actions that occur. Commingling occurs here, just as it does in the law of trusts, and we'll see identical issues in trusts and in remedies involving commingling of bank accounts and, a lot less commonly, life insurance policies. Then, Van Camp and Pereira. For those of you who are not Californians and who haven't studied this law before, these are two cases that deal with ways of allocating property interests in property that has been improved by the community labor of a spouse. It's also possible to do something called a reverse Van Camp-Pereira analysis, and I'll show you how those work exactly as they actually are tested on the California bar exam. Another action that occurs, real property appreciation, or perhaps in the modern marketplace, depreciation, or other changes in value of various items of property. And then another common action that is tested all the time, transmutation. And what's funny about this, transmutation is being tested very regularly in California, but the law changed 25 years ago or more, back in January of 1985. That was when oral transmutations became invalid in California, and we're still doing factual analysis about transmutations in the 21st century. Finally, I list a number of presumptions. Again, these are not intended to be every single presumption, but if you take this approach as a whole, I think you'll find that virtually all of the testable issues are alluded to one way or another. The basic presumption is property acquired during marriage is community property, and that's true about obligations that are acquired during marriage as well. And the flip side of that point is property or obligations acquired before marriage are the separate property of that spouse. Also, we often see presumptions based on the form of title. This is a crossover to real property, and remember, in California, we will not allow the form that title is taken to arbitrarily change the form in which title will be deemed held here in family law court in California. It's a reasonable presumption, and we will see examples in our work together where the result goes either way. Putative marriages and meretricious non-marital relationships are not infrequently included one way or another on the California bar, and quasi-community property also is commonly tested, and when it's tested, it is tested in exactly the same way over and over again. And the reason for that is there just aren't that many issues, and so they end up being tested the same way repeatedly. Finally, the last thing I list under presumptions is really just another commonly tested issue related to creditors' rights to either community property or separate property. And the most complicated issue here, which has been tested more than once in the last 10 or 15 years, is child support. And the wrinkle presented by this issue is, here's an example where a separate property obligation arising before marriage can, in fact, become a community property obligation. Here's the idea. Suppose we've got a spouse who has a prior child support obligation at the time of his or her next marriage. Well, at this time, the separate property of the parent spouse is primarily on the hook. But suppose we've got a new spouse with a prior child support obligation who doesn't have any separate property. Who's on the hook then? Answer, the community will be on the hook for that. Now, suppose the parent spouse obtains a big bequest or some other big pile of separate money after marriage. Does the community have a right to reimbursement for the earlier part of the marriage when there was no separate property? Answer, no. Okay, that's it. Those are all of the issues relating to child support, and I will show them to you in just that much depth as they actually are tested on the exam. So, that wraps up a very concise analysis of community property. Remember, community property is just like evidence in that we will address each item of property separately, and we will analyze it with exactly the same structure every time. We will talk about the source, we'll talk about the actions relating to that item of property, and then we will apply the law to reach a very specific conclusion which is directly responsive to the call of the question. Remember, in community property, the facts matter as much or more than they do in any other subject. We have to find a home for all of the details. And finally, remember, up front, we consider not a lot of boilerplate about community property law, but instead the specific facts about the relationship that we are being questioned about. And our job up front is to apply California community property law, either because we have a California marriage which is breaking up in California, or because we have a non-California marriage or a marriage with some other complexity, like, for example, a prenup. We consider those issues up front, and then we go into our analysis of each item of property. That's it. Good luck. And I think you'll find that even if you use no other resources, you can learn all you need to about community property from doing the questions in this seminar.